The title of the lecture is Contracts for Carriage of Goods by Sea in the Spanish Maritime Navigation Act of 2014. And the focus will be on jurisdiction and arbitration clauses. So, Achim, please, the floor is yours.
Thank you very much, Igor. To situate you, imagine the following situation: you have a buyer who's domiciled in Spain who buys from a seller who's domiciled in Brazil. It's a freelance sales contract. So the transfer is to be organized by the buyer. What do they buy? Like plants. Say plants. Since the buyer is a shipper, he contracts with the carrier who is, say, domiciled in Germany. They sign a bill of lading contract over the transfer of the plants, and the contract includes a law and jurisdiction clause, which is the clause included in the 2016 Conline bill form. It's a standard jurisdiction clause, which mainly says that disputes arising out of or in connection with this bill of lading shall be exclusively determined by the court and in accordance with the law of the place where the carrier has its principal place of business, as stated on page 1, the first page of the bill of lading, except as provided as herein. So, in execution of this contract, the carrier carries. He sails to Brazil, picks up the fruit, and carries or pretends to carry the fruit to Spain. Unfortunately, the container is not connected to electricity. It's very hot, and the plants leave Spain in a very bad condition. So, the question is: if the shipper who is domiciled in Spain, who is the shipper in the bill of lading contract, may go to a Spanish court and take his rotten plants there. And this is what I'm going to speak about. Mainly, can he or can he not? So, as you know, the Arbitration rules are silent on jurisdiction issues. Nothing in the rules says where to file the claim. Rotterdam Rules is a bit different. There are rules on jurisdiction, but they are opt-in rules. So, if the state ratifying rules does not opt into these provisions, they do not apply. So we don't know what will happen. We don't even know whether Rotterdam Rules will enter into force sometime in the future. But for the time being, the Arbitration rules are silent on jurisdiction issues. So we will have to move on to general rules on private international law, which within Europe is basically Brussels 1A regulation, Articles 71D and Article 25. Or if the regulation is not applicable, we would have to move on to national law. Just shortly, under Article 71B of the Brussels 1A regulation, if there is no jurisdiction clause, the claim can be brought at a place where the services were provided or should have been provided, which we do not know exactly where that is. I mean, in a contract of carriage, you would imagine that at least the port of discharge is the place where the services are or should be provided, but probably, and I say probably because the judgment you see on the slide on the right side is not on maritime transport, it's multimodal mobile transport, but there the Court of Justice said that the place where the services are to be provided or should be provided is not only the place of delivery, but also the place of dispatch. So if you have a pure maritime contract, possibly a place where the service is to be provided is also the place of dispatch. But at least we have one possibility, which is the place of delivery, possibly, probably the place of dispatch. And the Spanish law, we do have a special rule on jurisdiction, with Article 469, which says that except there is a validly introduced, I would like to stress this, validly introduced jurisdiction clause, the plaintiff can choose between the courts at the domicile of the defendant, which is obvious, but also the place where the contract is entered into, and similar to Article 71B of the Brussels 1A regulation, at the port of unloading. But of course, if Brussels 1A is applicable, Article 469 is not, the basic rule of European law. So, since the port of unloading is a possible forum, if there were no jurisdiction clause, the shipper in this case could bring a claim before the Spanish court. But it is very frequent that the bill of lading includes a jurisdiction clause, and it is generally to be found in general conditions. We submit a claim to a specific court. The jurisdiction, obviously, since the bill of lading is made up by the carrier, is the jurisdiction at the domicile of the principal place of business of the carrier. This is what the Article 4 or Clause 4 on Land Bill 2016 says. In relation to this, perhaps just remark that the Court of Justice has said that it's not necessary to say, okay, in case of big dispute, we have to go to the court in Castellón, but it is enough to say we have to go to the court as the principal place of business, because there are objective criteria which permit us to determine which is this court at the principal place of business. However, if there is a submission to foreign court, as you all know, this definitely hampers the exercise of the shippers or the consignees, whatever the case may be, claims against the carrier. Because if you have to litigate in England, you will perhaps think it twice, because costs are immensely higher than if you litigate in Spain. So, which is the solution under the Spanish Maritime Litigation Act? I will sum it up. We have two articles which are important in this regard. The first one I'm going to talk about now is Article 468, which says that without prejudice to the terms foreseen in the international conventions in force in Spain, we will be able to speak about this later on. Clauses of submission is a jurisdiction clause or arbitration clause that sends the parties to jurisdiction, to an arbitral tribunal abroad, is null and void unless it has been negotiated individually and separately. As you can imagine, if the jurisdiction clause is in general conditions, it will normally not have been negotiated individually. And indeed, the article itself says that the insertion of the jurisdiction or arbitration clause in the printed conditions does not fulfill this condition. I will speak about Article 251 later. So the clause we have just seen, which submits controversies to the court at the principal place of business, is null and void under Spanish law, but perhaps we could say yes, but it is only perhaps. But perhaps because these clauses are not negotiated individually and separately, and furthermore, the bill of lading does not have to be signed by the shipper. Most probably it's only signed by the carrier or by the master on behalf of the carrier. Why is it only perhaps? Perhaps because Article 468 itself says that, well, first we have to have a look at European law and international conventions. It is of course not necessary, but it is a useful reminder. We can not just skip European legislation, go directly to Spanish national law. And which are these international conventions and EU rules? Basically, Brussels 1A. Obviously, we have just seen this, which is directly applicable in all member states. But we can also have a look at the Lugano Convention, the 2007 Lugano Convention, which applies to relationship with the other EFTA states, Switzerland, Norway, and Iceland. We might think about the 2005 Hague Convention of Choice of Port Agreements, but it does not apply to carriage of passengers and goods, but it might apply perhaps to bareboat charter. So there is some applicability, not carriage of goods, but other maritime contracts, perhaps. And this is an arbitration clause, of course, in 1958, New York Convention on Recognition and Enforcement of Foreign Arbitral Awards. I will center on European regulation. Other conventions are, well, and Lugano Convention is very similar, so we can situation is similar, and the rules apply mutandis. And recast regulation says in Article 25 that if the parties, regardless of the domicile, have agreed that a court or the courts of a member state are to have jurisdiction, well, this agreement usually is valid. In which cases, in cases it is made in writing, by evidence in writing, it is in accordance with previous practices among the parties, or in international trade or commerce, and this is important, in a form which accords with the usage of which the parties are or ought to have been aware, or which in such trade or commerce is widely known to and regularly observed by parties to contract the type involved in the particular trade or commerce concern. So if the German defendant in this case, which is the carrier, makes a plea to the jurisdiction, what would be the solution? Well, since the court agreed is an EU member state, or is in a EU member state, the recast Brussels 1A regulation doubtlessly applies, and it applies as interpreted by the Court of Justice, who has handed down 3 very important judgments on jurisdiction clauses in bills of lading. The first one is from 1984, so you can imagine the recast regulation was not then enforced. It was enacted in 2012, and not even the original Brussels 1 regulation was enforced, which is of 2001. So what did the Court of Justice apply then? The Brussels 1 Convention, which had a very similar wording. And it said regarding this convention that a jurisdiction clause is valid if there is an agreement, and this agreement between the parties has been expressed in writing, made orally, and evidenced in writing in the bill of lading, or if there is a previous business relationship between the parties where a similar action has been observed. And this clause is enforceable against a third party holding the bill of lading. We'll see who this third party may be. If the clause itself, the jurisdiction clause, is valid as between the shipper and the carrier, and then if the third party succeeded by virtue of the relevant national law, we'll see which one it is, to the shipper's rights and obligations when he or she acquires the bill of lading. The second important judgment is Castelletti. You see it's from 1999. Before this judgment, there has been an important modification to the Brussels Convention. It added this clause we have seen before, these usages in international trade, which are known or should have been known to the parties. Of course, consent is still necessary. And if there's consent, there's no jurisdiction clause, which is obvious. But such consent is presumed to exist where the conduct is consistent with such international usage or usage in this specific area of international commerce. The awareness of this usage has to be assessed with respect to the original parties of the Puetz Port Agreement, shipper and the carrier, and additional requirements under national law shall not be taken into account, which would be this separate and individual negotiation under Article 468 of the Maritime Navigation Act. And the third judgment is Carriage Maritime 2009-11-2000. Which says that it is sufficient that the clause state the objective factors that permit to identify the competent courts. We've just done this. And for the Brussels Convention to apply, at least one of the parties must be domiciled in a contracting state, today in a member state of the EU. The parties must have agreed to submit any dispute before court of a contracting state. And if the claim is brought before court of a contracting state, although the jurisdiction clause remits to the court of a non-EU state, we do have to apply national law at the seat of the court, the lex form. And it also said that the third party holding the bill of lading is only bound by the clause if, according to national law, we'll see which one, he or she succeeded to rise in the obligations to shipper, or, and this is also important, or if he or she has accepted the clause according to the rules we have just seen, evidence in writing, previous relationship between the parties, or international usage. I will skip these other two judgment, this other judgment and the Italian torpedo and move on to, well, what happens. So since Article 25 envisages this possibility that the submission is valid even if the clause has not been signed by the shipper, and since European legislation has primacy over Spanish national law, in this case where the action is proved by the shipper, Article 468 does not apply. There may be some doubt where the courts mention the jurisdiction clause as Spanish courts, but well, I lack some time and I won't be able to answer this question. So accordingly, since Article 469 is not applicable, the plea to the jurisdiction will probably succeed. I say probably because opinions in the Spanish Court of Appeal are not unanimous. So my guess is that that plea to the jurisdiction will have success because the carrier is domiciled in Germany, which is an EU member state, and we do have to apply the Brussels 1A situation. So what happens in the other situation where the claimant is the consignee or the insurer of the goods who has surrogated the right of the consignee? So here the situation obviously is the same. We have still a Spanish buyer, we have a Brazilian seller, but now it's not a free alongside ship, but a cross-insurance freight sales contract. So the carriage has to be organized by the seller, and the buyer is the consignee. We have the same problem. They are shipped, it's hot, the plants are rotten, and the buyer consignee takes the rotten plants to Spanish court. So here the situation or the solution depends on another article, which is Article 251. I will go back a moment to show you what Article 251 says. I'm sorry, I should have changed this in the presentation. It says that it talks about the effectiveness of conveyance. That is what happens when a bill of lading is conveyed, is transmitted to third person. And it says that conveyance of the bill of lading shall take the same effect as delivery of the goods, but the acquirer of the bill of lading shall acquire all rights with the exception of agreements regarding jurisdiction and arbitration, unless there is separate and individual negotiation. So of course, here the situation is a bit different. We would have to see if Article 251 applies. If it applies, then the consignee is not bound by the jurisdiction clause in the bill of lading, even though it were valid between the shipper and the carrier. But this is only possible if, in the first place, the bill of lading is indeed transferred to the consignee, which is debatable, if he is already mentioned in the bill of lading at the beginning, because then there is no conveyance. But perhaps, since there is an evident similarity to Article 3.4 perhaps which we read, probably we can say that it is conveyed. And secondly, that the law applicable to the conveyance, to the transmission of the bill of lading is Spanish law. But is this the case? Well, it's difficult to know, because the Rome 1 regulation on law applicable to contractual obligation excludes negotiable documents, so it is of no use here. And if you go to the Spanish Civil Code, we have different possibilities. It can be the place where the goods are situated in the next city, which would be obviously Spanish law, so we could apply Article 251. But we can also go to the place where the consignment note or the bill of lading was issued, which would be Brazil. And if there is endorsement or another form of conveyance of the bill of lading, we could also have, we could take into account the law of the place where the bill of lading was endorsed, which is a solution adopted under Spanish law for bills of exchange and checks, which are also negotiable documents. So what will happen? Well, if the law applicable is really Spanish law, then the jurisdiction clause is probably for Spanish tribunals not enforceable against the consignee. So you see the difference. If it is the consignee who brings the claim, he is not bound by the jurisdiction clause because he is not a party to the clause, debatably. But if it is the shipper, then he is, because he made up the bill of lading contract with the carrier. But as I told you before, the Court of Justice has also said that if the jurisdiction clause is not transferred to the consignee, it is still possible that he consents, gives his consent, accepts the jurisdiction clause, according to Article 25. And there are once again the usages. So if there is usage, we already know there is, and the consignee knew or should have known that this usage existed, possibly there is consent, although there is no individual and separate negotiation, and the jurisdiction clause would be enforceable against the consignee. But this is not the opinion of the majority of the Spanish court. And just 1 minute and I will finish. What happens if the carrier is a non-EU carrier? Well, of course, in this case, the jurisdiction clause would lead us, for example, to a Chinese tribunal, which is not an EU tribunal, and then the situation, of course, is different. The recast regulation does not apply. We would have to move on to national law. Article 461 applies. The jurisdiction clause is null and void in the relation with the shipper, and of course, if it is null and void, it is not enforceable against the consignee. Well, and I will skip this last possibility and just conclude that the only certainty I really have is that where the court designated in the clause is an EU court, Brussels 1A regulation applies, so Article 468 is not applicable. And the other conclusions are hypotheses. Possibly Article 251 may apply, so the clause is not enforceable against the consignee. And of course, we are in need of a judgment by the Supreme Court, or the other possibility, and Juan Pablo just mentioned it, the Maritime Navigation Act is under modification, and one of the modifications envisaged affects Article 251, which would now say that the law applicable to the transmission of the bill of lading is the law that plays at the port of discharge, which under all these hypotheses is always Spanish law. So as you can see, this is a very protective legislation for claimants in Spain, which has been criticized by some scholars, it has been welcomed by others, but the law is as it is. And as I told you, the Spanish tribunals are generally quite favorable to the interests of Spanish claimants. So thank you very much.